Great, we're now live and back from our short break. Thanks to everyone who's rejoined us. My name is Katie Ambrogi, and I'm an attorney advisor at the FTC's Office of Policy Planning. And I'm really thrilled to be moderating this panel on remedies, where we will explore the range of potential solutions, both in law and in policy, for competition challenges in markets involving big data. And this includes a wide range of potential remedies from licensing and divestiture of data sets in the merger context to other possible options such as data portability and interoperability. So I'm thrilled to have these wonderful participants on this panel, and I direct you to their full bios for their list of accolades, but just by way of short introductions, we have Andrew Gavel, who's a law professor at Howard University and past director of the FTC's Office of Policy Planning. Courtney Dyer, who's a partner at O'Melveny & Myers. Frank Pasquale, law professor at University of Maryland's Francis King Carey School of Law. Kevin Bankston, law professor at University of Maryland, sorry, I'm rereading Frank's bio, moving right along. Kevin is director of New America's Open Technology Institute, and then Daniel Sokol, law professor at University of Florida Levin College of Law and senior of counsel in the DC office of Wilson Sonsini. So we will follow the format of each participant will give 5-minute opening remarks, and then we'll have a moderated Q&A. And as with past panels, we'll have someone from the FTC walking around taking your questions that we will incorporate into the Q&A. So without further ado, we'll start with Professor Gavel.
Thank you, Katie, and good morning, everyone. Just thanks to the Federal Trade Commission and to Bilal Sayed, the director of the Office of Policy Planning, and Katie, and to American University for hosting today. It's a pleasure to be part of this discussion, and I'm glad to be here. Just a quick disclaimer that anything I say today are my own views in terms of what we might be talking about in remedies. I guess the big point I would like to start with is that remedies are all too often thought of and discussed in a context of a litigation mindset. And even this morning, you could see that a lot of the discussion about big data related theories and issues have been focused on litigation. And what I'd like to suggest is that the FTC has a far broader set of tools available to it. And I'll start by talking a little bit about the limitations of litigation remedies and the possibilities for far more flexible remedies using some of the other tools the FTC has, particularly competition advocacy, which the Office of Policy Planning has historically done a lot of. Debates about privacy, big data, and competition are more likely to play out actually in the context of legislation, regulation, self-regulation, industry standards than they are through conduct-focused enforcement. Enforcement takes a long time. The agencies may, through investigation, be able to identify particular conduct that is worthy of an enforcement action. But if we look back historically, and this was something the panel was talking about this morning as well, it has become very difficult to bring Section 2-like cases, even for the Federal Trade Commission. It is a long process. It takes years in some cases. And if the notion is that we're going to, at the end of the day, have structural remedies, well, go reread the decision of the DC Circuit and Microsoft and look what the standards are for trying to impose structural remedies in the case of conduct that is anti-competitive as opposed to conduct like serial mergers. So it's very hard to win on liability. It is very hard to achieve remedies. Remedies are generally constrained in the context of litigation by prior cases. And so All of that plus the likelihood that we're going to see a variety of issues dealing with big data and competition arising in the context of, as I said, regulation, legislation, and even self-regulation, leads me to think that the agency ought to go forward with a fuller appreciation of the range of tools available to it. So why do I think some of those tools are better? So let's think about typical litigation is going to be after the fact. And if we are thinking, as was clear from this morning, about exclusion, we have that problem of the rivals perhaps being vanquished or gone, and there is no remedy that can bring rivals back from the dead, not for a court. So what's the benefit of the agency being engaged sort of at an earlier stage, following industries, looking at guidelines, looking at the possibility of comments on legislation and regulation? Well, it's before the fact, so there's an opportunity there to influence the direction of industry. The other advantages are cost-effective. It is a whole lot less resource-intensive than bringing enforcement actions. To think in terms of an advocacy program, it is a lot quicker and more nimble, and there's a broader range of possible solutions. And we'll talk about, as the panel progresses, what are the concepts of things that might fix competition problems. And I think that's the big point I'm trying to make is, if you start thinking about remedies solely in terms of litigation, you think of enforcement and you think of remedies that are geared to the particular conduct in the enforcement action. If you start thinking about competition advocacy more broadly, suddenly you have a wider range of potential ways to influence the direction of the market, to use the FTC's voice through speeches. Like I said, through comment letters, but also a whole range of things like these hearings, which are a form themselves of soft advocacy. And they are much more flexible, and you can use them in different ways to build agency expertise, and it might later translate into support for enforcement, but it should be part of the bigger package of remedies that we think about and talk about today. Remedies for competition problems, not necessarily remedies for anti-competitive conduct.
Great, thanks. And now Courtney?
Hi, thank you, Katie, and good morning, everyone. Thank you for inviting me to be on this panel. I'm honored to be here. As the practitioner on the panel, I want to talk about my experience in merger remedies that seek to address competition concerns where data is involved in the markets, and the challenges that they may present that are a little bit different than what you see in a traditional context of divestitures. Two things I wanted just to kind of touch briefly on this morning before we talk more amongst the panelists is, how you define the assets to be divested when data is a part of those assets. Data remedies have been or seem to be inappropriate in cases where you are trying to restore competition in markets where data itself is the relevant product market or a key component of the relevant product market. But once you define the asset and the agencies identify what they think needs to be divested to restore competition, I think it's really important to ensure that that data remedy doesn't lessen the incentives of either the merged party or the remedial party to innovate and to use that asset to create value and to use that data to compete more efficiently in the market. In defining the assets to be divested in some cases, like the CoreLogic case, the relevant product market was the data itself. And so the FTC alleged that CoreLogic's acquisition of DataQuick would lessen competition in the license of publicly available real property data to third parties. And so it required CoreLogic to license that big set of nationwide real property data to a remedial party so that it can relicense it to others in competition with CoreLogic. So the actual product was this nationwide set of house and property and tax characteristics. In others, the data has been a critical component to what the agencies have defined as the relevant product market. In Nielsen and Arbitron, the FTC required the divestiture of assets related to Arbitron's cross-platform audience measurement business, and it was then in development, and Nielsen and Arbitron were the only two developing this business. But along with that divestiture, required a royalty-free perpetual license to Arbitron's individual level demographic data that it collected through its audience measurement panel. And the FTC in this case found that Nielsen and Arbitrum are the only ones who had these audience measurement panels. So the data that's required to fuel a cross-platform audience measurement system was required to be licensed to a remedial party for them to be able to compete going forward with Nielsen. Similarly, in Google ITA, the DOJ required Google to license ITA technology and the underlying C-class and fair accessibility data to online travel intermediaries. Google planned to compete with against these OTIs with the assets it acquired, and the agency was concerned about foreclosing these OTIs from access to that same data to be able to compete in the market. In each of these matters, the agencies concluded that a data remedy was appropriate when, again, the data itself was the relevant product market, and they found that that market had few competitive alternatives for that data, or in a product market that relied on the data that only the combined company would have access to after the transaction. But once these assets are defined and these remedies are crafted, I think it's important to ensure that the remedy preserves the incentives of both of the remedial party and the merged firm to use those assets to innovate and to not impose conditions in those agreements that get beyond what is necessary that may have an impact of deterring companies from applying kind of their own expertise and ingenuity and innovative spark to really derive assets from that data. With regards to the remedial party, I think the agencies should avoid overly prescriptive remedies that may reduce their incentive to enhance the data. It may be, in cases, less important for the remedial party to step in the shoes of the acquired entity's current customer contracts, for example, by forcing the merged party to divest ancillary products that may be outdated, or complementary data that the remedial party may be able to obtain on its own more efficiently. And more important, to provide the technical resources and knowledge for the remedial party to be able to use that data and to incorporate it into an existing business or sell products and market products to new customers, because data-driven markets are innovative markets and ones in which they change rapidly. With regards to the merged firms, I think it's important not to deter them from taking advantage of the efficiencies in the transaction by forcing them to pass along any R&D and any enhancements that they want to make to their new data set to the remedial party and to their competitor. And behavioral remedies that go along with these structural divestitures do have, through the compelled licensing, the risk of losing the incentives for the merged firm to continue to make the products better. Thanks.
Thanks, Courtney. Professor Pasquale?
Yes, and for the slide, should I, is there a controller, or, sorry, or should I stand up from there?
I can just pass it down.
Oh, thanks so
Thought
much.
he was standing up.
Great. Let's see. Excellent. Well, thanks so much. And I just wanted to begin my testimony today by thanking Katie and others. Oh, sorry. For the mic. Thanks. Just thanks so much, Katie, for terrific organization here and for the chance to speak about the potential for remedies, and especially to think about platform power and a new age of competition policy, particularly, as Alan Grunis discussed in the last panel, when the U.S. Might be falling behind if it doesn't think more creatively and expansively about the nature of its competition policy. So I want to be sure to emphasize that, as I mentioned in my book, The Black Box Society, we've got to think about new industrial combinations and new ways of using data as being something as epically different and important and in some ways unprecedented as the utilities that emerged in the late 19th and early 20th century. Now, of course, oftentimes there is a divide or a tension that is characterized between antitrust policy and utility regulation. But I think we also see the ways in which these can either complement one another and can lead to synergies, particularly in recent work by Spencer Waller talking about the nature of merger conditions as effectively involving agencies in ongoing regulation of certain entities, particularly in the high-tech context. I start here just with respect to data interoperability. I think that's really critical, and that the example of the FCC making people's cell phone numbers portable should stand as a great example of something that really increased the value of a certain service to everyone that was using it, and that was ultimately something that we could bring that sort of model and that sort of ideal to many different areas if we wanted to have an industrial policy that actually promoted competition or federations of social networks as opposed to one that leads to monopolization. I think also with respect to portability, again, data portability should be something that could be considered part of individuals' rights and an effort to create a competitive market in many of these data-intensive fields. With respect to licensing of intellectual property, I know there's been some talk about the ways in which certain firms can gain certain advantages over different fields and can attain just massive amounts of intellectual property, and that might be seen as an essential facility. And I think that a revival of that doctrine is necessary, or ways in which it could be implemented through, say, merger conditions or other sorts of conditions. Regulation, ongoing regulation, again, isn't our focus, but it is something that I think needs to complement these other pro-competitive elements. And I also just want to be sure to get into a few fines and thinking about how do U.S. fines for anti-competitive behavior, how do they compare to fines in other parts of the world? Now, in terms of thinking about these types of policies in cabining platform power, I like to draw a distinction between Jeffersonian tech policy and Hamiltonian tech policy. And this was drawn in an article I wrote for American Affairs a few months ago that I was very grateful to The Economist. They used it as their frame for their special issue on digital companies. And the Jeffersonian tech policy would be one that would encourage fragmentation of large firms. I mean, the ideal there would be potentially requiring a breakup of Facebook from Instagram, from WhatsApp, right? The idea there would be that you'd want to have more opportunities for individuals to socially network, to communicate, to do other forms of digital sociality without having to worry about one company gathering all of that data and sort of centripetally bringing together data in ways that increased its advantage over rival firms. But we also have to keep in mind Hamiltonian tech policy, particularly Kesabil Rahman's article, The New Utilities. And Rahman was a professor at Brooklyn. He is now leading the Demos Institute. And I think that his work in terms of firewalling core necessities away and recognizing these as infrastructural goods, of imposing public obligations on infrastructural firms, and creating public options all must be part of competition advocacy. So I have plenty more to say. There are other slides that will be entered into the record. But I just hope this is an opening to a conversation about thinking in larger terms and in a larger framework about the nature of competition policy and how we can add more dimensions to it. Thank you.
Great, thanks. Kevin?
Thank you, Katie, and thanks to the FTC for having me here for this important forum, where I'm going to talk a bit about the difficult but hopefully resolvable tensions between privacy and competition when it comes to portability and interoperability. Hypothetically, imagine that after a huge privacy scandal involving a social network that you use, you want to hashtag delete it. What about your data? What about your posts? What about your private messages? What about all those baby pictures? What are you going to do? There is, thankfully, I think, a growing consensus post-Cambridge Analytica that users should be able to take back copies of the data that they've previously uploaded to a service. And this is indeed now a right for Europeans under GDPR. And I think there are three good reasons for this. One, it respects the user's right to control their own data, as do privacy protections. Two, it hopefully lowers the switching costs for consumers that want to change services, similar to how number portability lowered the switching costs of changing cell providers. And third, it hopefully makes it easier for competitors to grow more quickly so that the network effects of the incumbents aren't insurmountable. So for example, it was thanks to portability of contact data that several of today's social network incumbents were able to grow so quickly in the first place. And now, there are several tools. Several of the larger companies have offered data portability tools for many years now. But post-GDPR, they are working to improve them both in terms of comprehensiveness of the data and usability of the formats of the data. But people have mostly just used these download your data tools to archive their stuff rather than move it, in part because they are download your data tools. Actually having to download your stuff and upload it out somewhere else, especially if you're a mobile user, is a pretty big barrier. And that's also been a barrier to like the development of recipients of that data. But there's been a positive development in the formation of the Data Transfer Project, which is an open source project that currently involves Google, Microsoft, Facebook, Twitter, where basically they are trying to develop standards for one button or a couple of drop downs, ability to move your data between services. And this is, I think, over the next few years is going to help us deal with the low-hanging fruit of portability. Things like your photos, your address books, your stored files, things that are based on common standards and that are clearly yours. But then we get to the edge cases. Let's come back to the hypothetical. Getting my photos out is nice, but what about the photos I'm in that aren't mine? What about the tags that people have added to my photos that I didn't add? What about my comments to other people's posts? What about other people's comments on my posts? Things that aren't clearly mine. And most especially, what about my social graph? What about the network of friends that is really probably the most important thing I'd want to be able to move? Many commentators, including my organization, want companies like Facebook to free the social graph and make it more portable. But unfortunately, it's not as easy as number portability because we're actually talking about the data of other people and about other people. Essentially, the same kind of profile and contact information that was at the heart of the Cambridge Analytica scandal in the first place, and sometimes contact information that my friends haven't even chosen to expose to me on the platform in the first place. Now, let's be clear, Facebook has been finding ways to avoid letting users get this kind of information out of the platform for years based on privacy arguments that were also super conveniently and suspiciously aligned with their business interests. For example, the privacy setting that lets you decide whether or not friends can download your contact information is set to default private, unlike almost every other privacy setting on Facebook. But especially now in the political and legal environment that we have, I can't blame them for being very wary of sharing such data. And there is a privacy issue there. And there's not an easy answer on how to square that privacy issue and the desire for meaningful portability, which takes us to the last important theme here, which impacts both portability and interoperability, that is, services talking to each other in an ongoing way. At this point, all of the incentives for the companies are to lean toward privacy over portability and interoperability whenever they're in tension, in a way that I fear will ironically strengthen their hegemony over our data and make it harder for us to leverage our data on other services. We're seeing this especially in the context of interoperable third-party apps that run on top of the Facebook platform or lately on the Gmail platform. Those types of open platforms have been a huge source of innovative features and tens of thousands or even hundreds of thousands of apps and new businesses and economic growth. But at this point, if I were one of the big guys, I'd be locking those ecosystems down pretty completely and only letting users interact with a much smaller population of companies that are already trusted and well-established and totally vetted. Spotify and not the little guy, Fortune 500 companies, but not the smaller companies, Google Drive and Microsoft OneDrive and iCloud, but not the scrappy new Drive entrant. And that is the trend, the direction where we're going. And so I think the big question on the table is how can the FTC and Congress and other policymakers ensure that we find the right balance to both protect privacy and ensure a continued competition and innovation in this space, which we can talk about in questions.
Thanks, Kevin. Professor Sokol?
Thank you. I also have slides. Which way do I press? Oh, big green. Okay. No, that's giving me a green laser. Oh, top. Here we go. And I'm still having problems. This one. Okay. Yes. Oh, before. How do I go back? Before I get to the slide. So pardon me for this. Just two quick thoughts. Frank gave a number of very compelling types of remedies. Two things I want to just add for the Q&A. Number one. I'd say remedies look different as between private parties versus when the government is a plaintiff, and I want us to think about that. Number two, also missing from the list was no remedy, right? Every once in a while, it could be that the best remedy is to not intervene because either it's on the merger side, and we think that these are complicated markets. Alex in the last panel brought that up. Others do as well. Sometimes no remedy simply because we don't have a good remedy. To that, two books roughly a decade apart that show really great case. Microsoft, Mediocre Remedies. We have the Page and Lopatka book, and then we have the Gavel first book. Both of them, to the extent they agreed on anything, it would be that the remedies were not good. So here we have some data-related rumors. We're going to get through some of this. So I'm going to talk about refusals to deal and essential facilities. So we have a number of refusal to deal cases, and I want to cabin this as different than essential facilities, because some of these cases in the lower courts actually made the essential facilities claims. At the Supreme Court level, that didn't come up. And and some of these are great cases. I mean, great in terms of doctrine. I love Lorraine Journal. I love Otter Tail. I love Aspen for what Aspen actually stood for. And so I think part of it is like, let's read the cases carefully, particularly the Supreme Court cases, for what they say and what they don't say. Now, what does this do specifically for essential facilities? The Supreme Court is deeply suspicious, particularly for a particular type of essential facility claim, which is involving a single firm type essential facility claim. This also on this they're very clear. They haven't totally closed the door on it, but they're pretty close to it. And the treatise is equally troubled by that. And what I would suggest once we get to Q&A is that there is good reason to be deeply suspicious of essential facilities as a single firm type claim. And so this is essentially what do we need to have, right? Bottleneck, and typically we see it, as Frank alluded to earlier, in a regulated industry type setting. And the real critical thing is here that it's really the only gateway available. And in this tech setting, we have to ask ourselves, is really this the only possible way that essentially, is tech some kind of public utility? Should it be regulated as such? And I suspect most people who are antitrust people would say no. And I think that that's the right answer. And here's the problem. The essential facilities doctrine, I think, creates a lot of uncertainty. I think that it's just not the right tool in this particular setting. And some of that we teased out why not. In the prior session, some of it you heard a little bit about yesterday, and I'd say I'd be very reluctant, based on what we know in terms of the economics right now, to impose this kind of framework. Refusals to deal are limited. Where exactly they're limited are going to be case to case, but particularly with regards to large firms, dominant firms, it's one thing to say refusals to deal. It's another thing to say essential facilities. I'm going to push back very hard against essential facilities. Refusals to deal are more limited under case law, and sometimes you get imposed. I think Aspen, where there was, the Supreme Court is even clear there, right? Even if it's at the periphery, it's something that is still good law. That's very different than what we're talking about today. Thanks.
Thanks. I think as the opening statements reflect, there are a wide range of potential solutions here, and each proposed solution has some upsides and some downsides to it. Ginger's presentation yesterday, I thought, laid out one way of thinking about a range of these solutions, and that might be that on the far side of no intervention to the other side where there's total intervention, you have the free market on the one hand, and then moving a bit towards industry self-regulation, then industry self-regulation plus consumer education, and then moving further along, ex post enforcement of the laws, and then moving on from there, anti-regulation of some of these conducts. So there's a wide variety of options and mechanisms to achieve these options. So we'll try to touch on what folks have discussed in their openings. And we'll begin by looking at some of the practical aspects that we in the antitrust community are maybe more familiar with through our agency work, and that is in the context of FTC and DOJ consent remedies, in the context of mergers, is data different than other assets like factories or retail stores? And does data present unique challenges when compared with some of these other assets? And if so, how can data remedies be tailored to effectively remedy competitive harm? And the point to remedy competitive harm, as well as what Courtney mentioned, to preserve incentives that the merged party has to keep innovating and keep providing good products to the market. So we'll start with Courtney, if you want to respond to that.
Sure. So, from a practical matter, the data, and I can speak personally to the CoreLogic matter, which is ongoing. But in that case, it was public data that anybody could go out and get from county assessor and recorder offices. I mean, the complexity of it involved going out and collecting it from all of the counties and the offices and all of the jurisdictions across the country, processing the data, normalizing the data, and getting it in a format in which you can license it to third parties. So there's the aspect of the strict, here's the assets to be defined, here's the data that needs to go to the remedial party. But with that said, agreements, the remedies that impose some long-term entanglements between the parties, I don't think are necessarily always beneficial. I think it's important, and you'll see in these remedies that involve data, there's specific provisions on making sure that you give them the technical knowledge and access to employees and information that they'll need to be able to use the data and get it to consumers, access to business records, customer contracts, et cetera, and then unfettered ability to hire employees without the risk of them getting counteroffered and hired back by the merged party. And those come in a variety of contexts and obviously are very case specific. I think those are important to promote that the remedial party doesn't just take the data and step into the shoes and do exactly what a company did at a specific point in time, but has the knowledge and the tools and the resources to be able to enhance that data, incorporate it into complementary businesses that they might already have, and attract new customers, because this data is current data that is being updated daily and delivered daily to the remedial party and then to third parties. I think what makes it a little more complex in a data context too is, unlike a retail or a factory type divestiture, and you've got goods you've got to deliver to customers, here you've got maybe the same exact data, the number of bedrooms in a house, being delivered to a customer that might want to incorporate that into an MLS listing or otherwise. But you've got them wanting you to call the field a different name, or wanting you to format it with a comma in this space versus this space. So you've got all of these customer interfaces that are different. So you've got to be able to, pass along that knowledge too, so they can actually replicate what each of the customers of the acquired party had at the time. So it adds some complexities into that. In terms of tailoring the data remedies, again, I think the focus should be on how to get the remedial party to be able to use this data in a way that enhances competition in the market. And I think through that you need to be able to pass on these technical knowledge and these resources. And I think it has to be less focused on making sure millions of records are delivered perfectly to the remedial party, and more about being able to successfully interpret and adapt that to attract new customers in an industry that changes all the time.
Makes sense. Anyone else want to weigh in on this topic? Frank?
I just wanted to just make a quick intervention to say that I really valued Senator Warner's staff's proposals for 20 different types of social media regulation. And part of the foundations of those proposals was the idea that once an entity has a certain very large amount of data and a data advantage, that data advantage can become self-reinforcing and almost insuperable. I was making that type of argument back in 2008, 2009, and was laughed out of some rooms where people told me, you're talking about Google now, but Google won't even exist in 10 years. No one will have heard of the company, right? And so what we're seeing is that very gradually, establishment economists and others are starting to catch up with the reality of insuperable data advantages and self-reinforcing data advantages, and that is something that makes data very different than many of the other contexts in the precedents that are now governing this field. Thanks.
I think the last two comments sort of highlight a point I was trying to make earlier, that when we're talking about remedies in the context of litigation, it's really quite different from when we're talking about it in the broader context of some kind of regulatory setting, where you can really think much more broadly about what you want to do. But I want to say one thing about, in response to Katie's question, is it the same, is it different? I think the answer is it's both. That data can have sort of similar characteristics to, we're going to look at competitive overlaps and we're going to do some kind of slice and dice remedy. Now, putting aside whether those kinds of remedies actually work in the typical horizontal merger, 2 points I would suggest. One is a point that was raised this morning. In cases where what we're worried about is post-merger exclusionary conduct, that might not be the right solution. It could be the kind of things that Frank and Kevin have talked about might be better solutions if what we are worried about as a result of a merger that will result in higher entry barriers, instead of thinking about slicing and dicing data, and again, something that's alike, we'd have to think about economies of scale, just like we would in breaking up factories. But assuming data could be sort of made into chunks of data or shared, it might be better to think about, well, what's the problem with the portability of the data? What's the problem with the interoperability of data? So it could be that we could think of a remedy as more directed towards the competitive problem. And that might be different for data than it might be in brick and mortar industries. So I think that, as was said this morning, it really depends on the particular case and the characteristics of the industry. Whether or not parties are willing to negotiate those decrees as opposed to litigate those sorts of remedies may make a big difference for the agencies. So I think what you're seeing is that there's this range of options. When you're in the litigation context, you really are limited by the facts of the case and the particulars and the willingness of the parties to either resolve it or litigate. Some data-related issues have been resolved through negotiation. Others have been more difficult. We've tried remedies involving technology industries that haven't worked very well. And that's why I think it's important for the agency to, not put all of its big data eggs in the enforcement basket, but to be mindful of the range of activities that are going on, some of which have been mentioned. Kevin mentioned some of the, whether it's industry self-regulation, whether it's bills being introduced. I think there's an important role for the agency to play in representing competition and making sure that sort of competition issues and competition values are at the table when we're talking about things like restricting data. We'll probably get into this a little later, but there clearly is a potential for tension between locking down data in the interest of privacy and what might be best for competition. And that's starting to emerge in a number of industries where essentially privacy could be used as a pretext for conduct that might eliminate competition, make competition more difficult.
And Andy, you mentioned some remedies where it hasn't worked out so well in the past with data. Did you have any in mind in particular?
So one of the more interesting ones are at the time, the U.S. government was not really fond of it, but here's an example. The Koreans, in looking in the Microsoft cases at what the U.S. had done in terms of remedy and what Europe had done in terms of remedy, kind of concluded that neither of those were very effective. The issue was the ability to switching costs for browsers and the ability of consumers to easily switch. And so they came up with a novel solution, which is to require that there be a browser option on the desktop to try and get at the entry barrier and switching cost problem. I don't know that they ever studied it and to see whether it worked. It ran into that problem, I think, that we talked about this morning, where consumer preferences for particular browsers was already fairly locked in. But that was an attempt to do the kind of thing that we're talking about, is use a remedy in a conduct case that might more directly address barriers to entry and switching costs by making it easier for consumers to do those things.
Just some quick thoughts. Some of this teases out what we've already heard, but just puts a different spin on it. I think that the most basic question is one of institutional choice. And the first one is this what is it that we're trying to solve, and what's the appropriate institution? So this builds on not what we just heard here, but also earlier today, Alex's framework of competition versus privacy. I'd actually say even across different institutions, going to what Andy's talking about, when we think about it as enforcement cases, in a litigation context, we're thinking about judges. Maybe sometimes we're thinking about ex-ante regulation. We have to think really about what's the appropriate institutional choice. Frankly, when we say market, that in itself is its own institutional choice as well. And so then the next question is, it's so obvious, but no one said it yet, so I want to take credit. Does the remedy actually fix the harm? Okay. Sometimes you get credit for saying the obvious. And I think that that's another important overlay in this kind of situation. And then it therefore goes back to something else Andy said, which is ultimately it depends on the situation. And therefore, we're going to see a wider variety of institutional choices and remedies based on the particular harm. But ultimately, the remedy only works if it fixes the harm. And then one final thought. The other agency has not taken kindly in the last 2 years to behavioral remedies. I'll suggest that sometimes behavioral remedies do work, but they actually have to remedy the behavior. To the extent that their critique is really, if the behavior's been going on for 60 or 70 years, that doesn't seem like an effective behavioral remedy, there's probably some truth to that. But I don't think that means that we should poo-poo behavioral remedies generally, when actually the behavioral remedy is a good fix for the harm.
Katie, can I add one more thing? Yeah. So one more thing I want to add. I think that there's a temptation to think of data as some kind of commodity, that, our data exists, my name, my phone number, my friends, that it exists in that way. And I think that part of the challenges, and I'd be interested in Kevin and Frank's response, because I think they know a lot more about the technology, but part of the concern I have is whether data really exists in that way as a commodity, or whether it is deeply integrated with analytics that a company may be using to sort of massage and create value out of that. And going back to Courtney's observation about mergers, there is an analogy here. So let's say we're going to spin off a factory, but we're not spinning off with it the real technical know-how, the company's magic sauce, that it knows how to operate that factory in an optimal way. So we spin off the factory, but it doesn't really have all of the tools necessary. Now, that's something that traditionally agencies take into account in thinking about divestiture remedies. But if we're talking about data, the first question is a technical one. Is it really separable from the analytics that's used to derive value from it? Does it really exist in that way? And even if it does, what is the use of separating out the raw data in a way that doesn't provide that same analytical ability? Now, maybe that's something that competition should be left to provide. If somebody wants the raw data, then they need to figure out what to do with it. But I do think that's something that potentially makes data a little bit different when we start talking about interoperability and portability, and you and I think about our name and our phone number. I don't think in many instances it's that simple.
Yeah. So, completely agree that it's not that simple, but I also think that it's very easy to overemphasize the tension between competition, promotion, and privacy. I know that James Gromelman and Randy Picker have done very interesting work in that area, but as I've studied that work, I have also simultaneously been working in the field of health data. And think about health data and regional health information exchanges as promoted by the Health Information for the HITECH Act, the Health Information for Technological, Economic, and Clinical Health of 2009. If you think about the ways in which we promoted interoperability and how the Office of the National Coordinator for Health Information Technology has released very sophisticated reports attacking information blocking by healthcare entities, we're not writing on a blank slate. We don't have a tabula rasa here. We have a very well-established history of health authorities using data, combining the data, and trying to gather that data in order to promote precision medicine and to promote cures. And if we had the same level of political will that we had about precision medicine and about promoting cures with respect to competition policy, we could think about ways in which to anonymize. We have the HIPAA de-identification standards that there was rules put out by HHS in 2012 on this matter. We have a whole infrastructure and apparatus of thinking about ways to share data safely. And I think that it's time to bring that here. I would also say that just with respect to Kevin's points, and I do think that there's a very important points, and certainly there are attacks on the idea of anonymization. There's a whole computer science literature saying it's very, very hard to anonymize properly. But I would say that at the very least, one might say that a simple rule would be anything I upload, I can download back, right? If I put up a photo, if I put a comment on, et cetera. And I think that would be at least some way in which we could try to ensure that there is a base level of this sort of interoperability and portability. And finally, I'll get to Andy's other point about the nature of inferences and data versus inferences as in recent European and California developments have shed some light on that. But I'll wait on that, so thanks.
If I can respond to a few of those points and answer some of the things I promised I would. First off, I tend to agree with Frank that the tension is not irresolvable, and that finding venues to actually work through these hard problems, the FTC being one of them, is critically important. I'm not quite sure how the health example bears on the social graph example, but I can see its application in other areas. In terms of what Congress and the FTC can or should do in this particular area, I think that Congress, as part of comprehensive privacy legislation, should include a basic portability right similar to the one in the GDPR. However, the one in the GDPR is really too simple in a way. It delivers this basic right and then says this right is completely subsidiary to all the other privacy rights, such that it basically sidesteps all of the hard questions and says no matter what happens, the privacy rule trumps. I would hope and imagine that something in US law would give more flexibility, perhaps through rulemaking at the FTC, that would allow for more specific regulation or guidelines in the harder cases where there's a particular competition or other consumer benefit need that countervails the privacy need. I also think it's important for the FTC, looking at mergers and acquisitions in this space, to look at the portability and interoperability practices of the companies involved and consider remedies that require new portability, that may require new interoperability. And there is some precedent for this, in the AOL Time Warner merger, when AIM, may it rest in peace, was at the time the dominant chat client. One of the conditions was they needed to become interoperable with, I believe, it was sort of staggered over certain months, but one or two other competing messengers. And so I think considering those kinds of things as we look at future mergers and acquisitions is going to be really important.
So a lot of good stuff here. I'm going to pose a question that came from the audience. It's rather a combination of a few questions, which all seem to focus on the same issue. So for remedies that involve forced sharing or interoperability or portability or licensing, or maybe just all remedies in this space, are folks outside of Courtney, who already articulated this, concerned about the effect on innovation, or do you think it will increase innovation, and or should we be worried about intellectual property rights in that space? Are those a hurdle to interoperability, and how do we think about those things and overcome some of those potential challenges?
I'll take off a bite of that. I am not concerned about a threat to innovation from requiring portability. I think it's worth considering maybe some sort of size threshold that you need to meet before that's required. But then again, there's also a value to forcing people to start with portability by design, just as we want them to start with privacy by design. Interoperability is very different, and this will require a little, I think there are two big models of interoperability online. There's the decentralized interoperability of open standards, where any of us can run an email server that can talk to another email server, or a web server that can talk to another web server. We used to have chat clients that relied on an open standard. Now we have a bunch of different ones with different standards. Then there is the sort of centralized interoperability of apps on a platform that are basically relying on data from a platform that they're running on top of. The Facebook platform is a good example. Both of these raise very different questions. And I think that, for example, mandating that a product design itself to be interoperable over open standards could entail a huge revamp of the product and could also limit certain types of innovation. I think, for example, there is a debate in the chat client world about it would be great if we resolved the fact that there are all these competing chat clients that don't talk to each other with a single standard, but even people like Moxie Marlinspike, the coder of Signal, are like, yeah, but if I tether myself to an open standard like that, I will be much slower in adapting to consumer need around features. And so there are definitely costs there that would need to be considered before you said something like, yeah, let's just make Facebook and Twitter be able to talk to each other. Making sure that companies that offer platforms are offering interoperability in a way that doesn't stifle competition, I think could be good for innovation. And I know I keep picking on Facebook, but they have a provision right now in their platform terms of service that says you can't have an app on the platform that replicates a core functionality of Facebook. So if you wanted to live on that platform while offering a newsfeed-like product or a direct messaging product, you can't do that right now. And so I think requiring that kind of interoperability would actually foster innovation rather than threatening it.
So thinking about requiring, what is the mechanism that would achieve some of these portability and interoperability goals? You mentioned that if there was comprehensive privacy legislation, that some of these could be baked into that legislation. So in the view of the panel, is that a role for Congress? Is it a role for the states? Assuming this is a goal, we'll leave the question of whether it is or isn't a state that we want out and talk about the mechanism. Or should it be industry self-regulation? Kevin, you mentioned the data transfer project earlier. What's the best mechanism to achieve some of these goals?
Since I've been talking a lot, I'll just say very briefly, I think mandating portability is straightforward and we should do it, but we should make sure we do it in a flexible way. I think interoperability is a much more case-specific, technology-specific, fact-specific inquiry, and just saying things should be interoperable as a mandate doesn't make any sense.
I'd also add, Katie, going back to your last question, that forced sharing is not the same as trying to come up with a system that allows things to be portable and interoperable. Forced sharing is like a dirty word in antitrust, and we associate it with undermining incentives for innovation, forced licensing, compulsory licensing. There's a whole bunch of imagery that goes along with that, but that's not necessarily what's being discussed. And the one thing I would add is, in terms of targets for enforcement, when you see conduct that is impeding interoperability, impeding portability, and doesn't really have a business justification. And this is what I said earlier. I think the health IT may be an example, Frank, where one of the arguments made is, oh, but we are really worried about privacy. And so we've erected these barriers to information flow in order to protect privacy. That's exactly the kind of situation where the FTC could play a role, saying, all right, well, you've adopted this pro-privacy policy. It has this anti-competitive consequence, and asking the traditional question that the agency has always asked, are there less restrictive available means to achieve that? Is it a genuine concern to begin with? Those are sort of the bread and butter of advocacies that have come out of the agency for years. And that might be an appropriate sort of use of that advocacy to identify things that are greater than necessary to protect some genuine issue. Last thing I will say about Trinco, because Trinco, I do want to pick on Trinco. One of the great colorful phrases that influences our thinking about force sharing is Justice Scalia's, "We must not reach into the bowels of Verizon." Because like judicial proctology, ooh, who wants to do that? So great phrase from Justice Scalia. That was the motion to dismiss case. Never got to any factual inquiry as to what really was required to facilitate the interaction of Verizon and AT&T was the company seeking access. You can look at that case and think of it as a refusal to deal case, forced dealing. You can also understand it as a dirty dealing case. It wasn't really about refusing to deal. It was about refusing to deal in a way that was required by regulation. So our imagery of these sorts of forced dealing cases has been influenced by a line of cases, and we ought to understand that, you know, the essential facilities, Arita wrote an article called An Epithet in Search of a Rationale. The Supreme Court cites it in Trinco. Obviously never read it because in that article he says he thinks MCI versus AT&T was rightly decided. What is that case? Is it essential facilities? Is it a refusal to deal? It's exclusionary conduct, and the labels don't really add much to it. So I'd be cautious about viewing these things as forced sharing.
And I think also one of the things that I think is really interesting, and you know, I've been following the debate about structural versus behavioral remedies, and you know, I was just reviewing this article by Cuoca and Moss, John Cuoca and Diana Moss from 2012, sort of critiquing the regulatory capacity, the capacity of agencies to sort of really monitor and follow up on behavioral remedies that are sort of part of cases like Google ITA, Comcast, NBC Universal, et cetera. And I think that there's a role that we should definitely have a sense of the limits there, but two caveats, one being, sometimes this is just a resource problem, right? It's just, do you have the resources to do what you need to do? And with like the FDA, when they didn't have enough resources, you have PDUFA, you know, in terms of the Prescription Drug User Fee Act, you have other ways of funding these types of activities. And so I think that having those resources, that should be something agencies should be unafraid to ask for. The other thing that I would note is that we've got to be really careful in terms of thinking about the context when we see a critique of any particular approach. So of course, originally when these big firms came up, there's utility regulation, but then that gets critiqued and people in antitrust say, you know, that is just so inefficient, really antitrust can solve the problem. But then when antitrust authorities try to impose structural remedies historically, then there was all this resistance, you know, and we've heard some of that in Andy's testimony earlier in terms of that. And so then they sort of back down to behavioral remedies. Now we're hearing that behavioral remedies are really very problematic and that they exhaust the capacity of the agencies and we can't pursue that. And so is the idea that we're eventually going to shrink it to nothing? You know, I mean, I don't know. And I think that if we don't complement those sorts of ideas with the idea that, hey, maybe the ultimate remedy is fines like what the European Commission can levy, 2 to 4% of global turnover, if we don't try to expand that, then we essentially have promoted a evolution in policy that just continually gets more and more shrunk as opposed to dealing with the lived realities of the new economy.
Just some thoughts. One, I'll push back against Frank in one area. So I think that agencies do best the things that are their core competencies. And so sometimes when you see an agency sort of shrink in terms of what it's willing to do, it's not because we think that there should be no solution. It's that there are other processes, other institutional choices, they're simply better suited. So we see across a number of different areas, agencies have overlapping or even, let's say, parallel powers, but not exactly the same powers, and they have different pluses and minuses. And so we should always think, you know, which agency is best suited, and by agency, I shouldn't say agency, right? Because I could be sometimes the remedy is statutory, could be the remedy is market, whatever it is. There is an institutional choice that seems to be better than the others in terms of ability to get at the problem. And again, all this assumes that there's a problem. It gets at the problem and does it more effectively. And part of, I think, we have to do is to figure out, which institutional choice is better at that. And I think a large of that goes to core competencies. The second thing is to take what Andy was saying and just extend it further with regard to Trinco, right? If the real concern was force sharing, and Andy says, but maybe it wasn't force sharing, maybe it was just a certain type of behavior, I think that the push at the time of the Supreme Court was send this to regulatory agencies because maybe that was the better institutional choice at that time. Whereas I'd say back to the MCI case and to AT&T, the problem is the FCC wasn't doing anything. And that's the reason why we, in terms of antitrust, really made the big difference in antitrust, because we saw a gap and a real competitive gap. But that's a very different question than I think the basic one today is if we're looking at data markets and competition problems. A, what are the specific competition problems case by case to what Kevin was saying and to Andy was saying, then which particular remedies can we map on to those specific competition problems and the kind of day-to-day work that the FTC does? And I think that's a little bit different than what we've just been talking about.
So I would just add one thing quickly to that, and it's the limitations of case by case. Case by case takes a long time, and it is, by its nature, case by case. And if there are broader issues in the industry, maybe as a result of these hearings, the agency will better understand them. And if there's active regulatory efforts going on, the agency needs to be at that table, and the agency needs to be thinking about what are the trade-offs that are being made to be a voice for competition. Because, again, that's where advocacy can actually affect the direction of an entire industry, where case by case tends not to have that broad an impact.
So we've touched on this a little bit. How likely is it that a plaintiff could succeed in arguing that data is an essential facility, or whatever you want to call it, unilateral refusal to deal, or that it's implicated in exclusionary conduct under the current antitrust jurisprudence? What would a plaintiff have to show? Anyone want to take that on?
I had a slide on that, where, from the Seventh Circuit.
Yeah.
It turns out it's not easy. Now, to be sure, that was a Section 1 case, not a Section 2 case. But it turns out it begs the question, is the data essential? Right? So even just to get to your question, there are a number of things we have to bake in, or there are certain ingredients that we need to have to even bake the whatever it is that we're baking, to figure out if there is some kind of remedy. So thus far, it seems not easy, but then it begs the question of, well, why is that? Is it not easy because it's just difficult to bring a case? Or is it there's something very interesting about this kind of case that perhaps doesn't lend itself to an essential facility? And that's where I would push you and say, it's not clear to me that these are essential facilities because of issues like multi-homing, because in fact data sets can be assembled and disassembled. With this is why I talked in the last panel about the entire data ecosystem. Can you more or less replicate the data? Can you buy the data from a third party, et cetera? There's a lot of complexity here, and when we reduce it to everything being essential, I just don't think that's right.
So I agree with Danny that regardless of the theory of the case, these cases are hard to bring. There's a reason that DOJ and FTC have not brought very many Section 2 unilateral conduct cases, and there's a reason you don't see a lot of private cases, and there's a reason that it's a challenge to find plaintiffs that prevail in any of these cases. There just aren't a lot of them because the law is very demanding. But I think the theory of the case makes a big difference, and this goes back to something we were just saying. If the challenge is simply refusal to deal, I want data, I want something that this dominant firm has, and the conduct is the refusal to share it, that's quite different from a situation where you have conduct that is impeding shareability or is in some sort of artificial way that's hard to justify for business reasons. And that's potentially a difference between looking at something like Aspen Skiing and Trinco. So I think that that makes a lot of difference, and the theory of the case would affect the theory of the remedy. But there's no doubt that these cases have become very difficult to bring.
Frank, I know you mentioned in your opening statement interest in potentially reviving some of these theories in the data context, and I wondered if you could speak to, your current understanding of a jurisprudence and what would it take to stake a claim in this space?
Sure. I mean, I think that one of the issues here is, and here, I mean, I think just to engage in like maybe a friendly colloquy with Danny, I mean, in thinking about this sort of area is, let's say that we had a situation with the acquisition of content in Google Books, and that was a long-term investment. Got to give Google a lot of credit for doing that, and very highly fraught with respect to would they win the fair use case against publishers. Could they coordinate libraries, et cetera, to acquire this massive collection of books? And you have also the possibility, and let's say, imagine that an upstart comes in and, I don't know, some foundation maybe gives someone millions of dollars, tens of millions, whatever it might take. And then the libraries say to them, look, we've already had our books scanned once, and to do it again, it's going to break the book's spines or something, or we just don't want to have this all done again, right? That's a situation where I think we have to think deeply about, just as we thought with respect to, do we want to have the sidewalks dug up 15 times so 15 different phone companies can bring wires to your home? We might think very deeply about to what extent do we want to force every book to be scanned over and over again, et cetera. Now, of course, the idea that would come back is who will, going back all the way to the 1995 guidelines and innovation markets, et cetera, the idea might be, well, who's going to invest all the resources necessary to put together a corpus this large if they know that it could essentially be licensed in the future, right? But I think that we've got to be able to respond to that in some cases and say that, look, we could create different types of fair and reasonable, non-discriminatory licensing patterns in many different situations in commercial life. This might be one that we should open up that sort of possibility to. So that's one example, and I know that the the interaction of IP in that makes it a little bit complex, but I still think it's interesting because data is those scans. I'd also say that with respect to gathering that data in alternative ways, I mean, I wrote a whole book, The Black Box Society, about how secretive these companies are, right? I've talked about, and this has been followed on by a big follow-on literature of a triple layer of legal secrecy, actual technical complexity, and purposeful obfuscation with respect to critical aspects of the functioning of many large tech platforms. So, and this was something that was, of course, part of the difficulty in ongoing regulation and enforcement of antitrust litigation with respect to Microsoft, say the trade secrets and different aspects of their platform, and so, or their software. And so what I want to just bring up there is that I don't think we can just very easily say, go get it yourself or go get that data yourself. It may be that for quite a long period of years, the only place that data exists is within this triply protected moat. It's like a moat, as Warren Buffett calls it, entities. And that we have to start taking more seriously the possibility that these are truly unique and essential resources.
The only thing I'd add to that is that there certainly has been a lot of literature generated about this tension between the innovation incentives of the incumbent dominant firm versus the innovation incentives of the challenger. And it's not easy to resolve that. This was discussed at this morning's panel as well. And we do have to be concerned about adopting standards that will inhibit firms from seeking to become a monopolist. One of the great lines from Judge Hand's Alcoa decision is, having encouraged firm to compete, we don't turn on them when they succeed. There's important antitrust sort of cornerstone to a lot of what we've done based on that. Having said that, I think sometimes some of the commentary focuses too much on fears about impeding the incentive of a firm that has achieved dominance and doesn't consider the impact of the potential innovation being offered by the entrant. And that's what brings me back to going beyond the simple refusal to deal and looking for conduct that is in some way affirmatively impeding that new entrant. Because that new entrant is also an important source of innovation for the economy. Striking that balance is difficult. The agencies have had to think about it. The courts have had to think about it. There are two sides to that debate, and we shouldn't dismiss either side of it, particularly when we've got exclusionary conduct.
And I would just add to that, that I think that, looking at some of Lena Khan's work on Amazon, it's very interesting to sort of think about some of those potential for intervention, and also Hal Singer's work with respect to pointing out what net neutrality can't do and what antitrust could do with respect to platform non-discrimination. So I think both of those are just to add on to Andy's points.
So how do we, at the end of the day, assess relative
It's not even lunchtime. It's not the end of the day.
the proverbial day? How do we assess the relative success of data remedies, and can we draw any conclusions today about past remedies involving data and any lessons learned?
I can start from a practical perspective with that one. I think, if you feel like you've got a remedy that's crafted appropriately in terms of getting what the remedial party needs to compete and restore competition in the market, I think data does present a little bit unique issues in determining the success of that remedy. It's one thing to say, okay, did you transfer, everything that manufacturing facility had into the hands of the remedial party. Here you're giving them big reams of data that they need to be able to use and incorporate into their business. But is the success that, every one of those millions and millions of records gets into the hand of the remedial party, or are they then understanding the data? Are they then acquiring data from other sources to enhance that data? Are they gaining new customers and attracting new potential customer segments to the market because of the innovative ways that they're using the data? Are they lowering prices in the market and not lose sight of the competitive dynamics that are happening as a result of the remedy, and focusing more on the technical divestiture to make sure they've got everything that they need? Because what they need may evolve as the industry evolves and technology involves. I think the other risk, too, is measuring success is, was the remedy too broad? And you've got some cases where these parties are forced to enter into remedial agreements with the remedial party that now gives them access to data that they can almost use unfettered, or at least unfettered in the context of the remedy itself. And that happened in the Nielsen Arbitron, where the data was supposed to be limited to being able to use the data for the cross-platform measurement services versus the television only, and the remedial party started using it for television only, and so Nielsen had to go and sue them privately because they couldn't resort to the agencies because they weren't a party to the agreement. Similar things have happened in other cases where, once the data is in their hands, how do you not give them an unfair advantage because they now have access to things that they can use to compete more effectively, but in markets that didn't need to have any sort of competitive impact restored.
How would we know if competition advocacy is effective in this space, and how would you suggest that that particular tool be implemented in a way that's effective?
It's always been a challenge for the advocacy program is undertaking efforts and using resources to look back at prior advocacies to see if they've been successful and how to measure success. The agency takes a position in favor of or against a regulation or a statute, and you could mark it as a success if the regulatory body or legislative body adopts the position that was advocated. But that doesn't tell you whether it was successful from the point of view of competition. So I think that that's an important question. It's why we do retrospective studies. It's why we do this sort of hearings to try and understand the state of the industry. And I think that to the degree we are still, I embarrassed myself yesterday in my complex litigation class by revealing to my class that when I was an associate, document review meant like really document review, sitting in a warehouse with documents. I think it's, and how much things have changed in such a short period of time. I think that we are still very early in the information age. We are early in dealing with these issues. I don't know that we have any data ourselves on big data remedies that is enough to answer that question. But I think it's important to the degree the agency undertakes either enforcement or advocacy that it think about how to answer that question going forward, how to track the results of their efforts so they do have a good sense of what is a measure of success and whether their efforts have succeeded.
Great, and with that, we're out of time, and join me in thanking our panelists for this discussion today. And now it's lunch. We'll be on a 45-minute lunch break, a little bit shorter today, but hopefully.